Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 25th March 2025 and we bring you news that matters. The first news for today is as follows. The Maharashtra government informed the Bombay High Court that a draft bill aimed at regulating private coaching centers is expected to be introduced during the State Legislative Assembly's monsoon session in July. This development responds to a public interest litigation, PIL, filed in 1999, highlighting concerns over unregulated coaching institutions lacking basic facilities and alleging that government-employed teachers were prioritizing private coaching over their official duties. The state's council referenced guidelines issued by the Union Ministry of Education on the 16th of January 2024, which urged states and union territories to establish legal frameworks for overseeing coaching centers. In response, the Maharashtra government has directed the Commissioner of Education to study these guidelines and submit a proposal. The High Court has scheduled the next hearing for the 28th of July. This move aligns with actions in other regions. For instance, in February 2024, the Delhi High Court mandated that coaching centers with over 20 students relocate from residential area to commercial spaces to ensure student safety. Next news. The Supreme Court has ruled that delays in recording witness statements under Sections 161 and 164 of the Code of Criminal Procedure, CRPC, do not automatically undermine the prosecution's case, provided there is a satisfactory explanation for the delay. In a recent judgment, a bench comprising Justices Abhay S. Oka, Ahsanuddin Amanullah, and A.G. Masi upheld the conviction of individuals charged under Section 302 murder, read with Section 34, common intention, or the Indian Penal Code. The appellants had contested their convictions, arguing that the eyewitness testimonies were recorded 3 to 4 days after the incident, which they claimed was detrimental to the prosecution's case. The court noted that delay in recording the eyewitnesses' statements was due to the investigating officer's engagement in maintaining law and order during riots in the area where the crime occurred. The bench concluded that in such circumstances, the actions of the police were justified, and no adverse inference should be drawn from the delay. The judgment emphasized that when a delay is adequately explained, it does not necessarily benefit the accused. This ruling underscores the principle that delays in recording witness statements must be evaluated based on the specific facts of each case, and a well-justified delay does not automatically invalidate witness testimonies. Next news. The Supreme Court has upheld the Life Insurance Corporation's LIC decision to reject a health insurance claim under the Jeevan Arogya policy due to the policyholder's non-disclosure of chronic alcohol consumption. In this case, the policyholder had denied any alcohol use in the proposal form. However, medical records during hospitalization revealed a history of chronic alcohol intake. The court determined that this non-disclosure constituted a breach of the policy terms, justifying the insurer's repudiation of the claim. This ruling emphasizes the critical importance of providing accurate information when applying for insurance policies. Failure to disclose habits like alcohol consumption can lead to denial or claims, especially when the undisclosed habit is directly related to the medical condition prompting the claim. Next news. The Supreme Court has quashed a rape case against a man, highlighting that a breach of a marriage promise does not automatically constitute rape unless fraudulent intent existed at the time of consent. India Today. The case involved a woman who alleged that the accused coerced her into sexual intercourse on 3 occasions, under the false pretext of marriage. Despite claiming distress after each incident, she accompanied him to a hotel room thrice. The court observed that her repeated willingness to accompany the accused contradicted the allegations of force. Justices Sudhanshu Dhulia and K. Vinod Chandran noted that the woman admitted to a close relationship with the accused, that the sexual encounters were consensual. They emphasized that for a rape charge based on a false promise of marriage to stand, it must be proven that the accused had fraudulent intentions from the outset. This ruling underscores the importance of evaluating the context and nature of relationships in cases involving allegations of sexual assault under the pretext of marriage. Next news. The Supreme Court has ruled that the delivery of possession is not essential to validate a gift or settlement deed, and once such a deed is accepted, the donor cannot unilaterally revoke it. In a case involving a father who executed a registered settlement deed in favor of his daughter retaining a life interest, the court observed that the reservation of life interest and postponement of possession to the donee does not render the document a will. The court emphasized that delivery of possession is just one method to demonstrate acceptance, and not the sole criterion. The receipt and registration of the original document by the donee constitute acceptance, fulfilling the requirements of Section 122 of the Transfer of Property Act, 1882. This judgment underscores that once a gift or settlement deed is validly executed and accepted, it cannot be unilaterally cancelled by the donor, reinforcing the irrevocability of such transfers under the law. Next news. The Supreme Court has criticized the Union government for failing to provide the promised ex gratia compensation to the family of Dr. Sunil Kumar, a government pediatrician who was fatally shot while on duty at the Community Health Center in Jaspur in April 2016. Despite the Chief Minister's approval of a 50 rupees lakh compensation, the family received only 1 rupee lakh, leading to prolonged litigation. Expressing displeasure over the 9-year delay, the court directed the state to pay 1 rupee crore to Dr. Kumar's widow. This ruling underscores the judiciary's stance on ensuring timely and adequate compensation to families of public servants who lose their lives in the line of duty. Next news. The Allahabad High Court has directed the District Magistrate of Hapur to expedite the processing and disbursement of ex gratia compensation to Aslam, a male acid attack survivor, within 4 weeks. Aslam, who suffered a severe acid attack in November 2016 resulting in 100% disability, had applied for relief under the Prime Minister's National Relief Fund. Despite a directive from the central government in May 2024 to verify and process his claim, no action was taken, prompting Aslam to seek judicial intervention. The bench, comprising Justices Ashwani Kumar Mishra and Arun Kumar Singh Deshwal, emphasized the necessity for state authorities to exhibit due sensitivity in such cases and ensure timely assistance to victims of grievous offences. Next news. The Bombay High Court has upheld an arbitrator's decision to defer the determination of a partnership firm's dissolution date until the final hearing, ruling that such a decision is not perverse under Section 30(4) of the Arbitration and Conciliation Act, 1996. The case involved partners in a textile manufacturing and trading firm who, after disputes arose, entered arbitration, as stipulated in their partnership deeds. During arbitration, some partners issued a dissolution notice, asserting the partnerships were at will. The arbitrator chose to address the dissolution date during the final hearing, prompting a challenge under Section 34, which allows courts to set aside arbitral awards under specific circumstances. The High Court concluded that the arbitrator's decision to postpone addressing the dissolution date was justified, as resolving this issue required comprehensive evidence and could not be deemed perverse. This judgment underscores the judiciary's deference to arbitrators' procedural decisions, when appropriately reasoned. And the final news for today is as follows. The Punjab and Haryana High Court has sought an explanation from the Punjab government regarding the delay in registering a First Information Report (FIR) against Punjab police officials accused of assaulting Colonel Pushpinder Singh Bath, an army officer currently posted at Army headquarters in New Delhi. Justice Sandeep Maudgil issued notices to the State and the Central Bureau of Investigation (CBI), requesting a comprehensive status report. Colonel Bath alleges that on the night of the 13th of March, 4 inspector rank officers of Punjab Police and their armed subordinates attacked him and his son without provocation. Despite the severity of the incident, local police reportedly failed to take immediate action. Initial distress calls to senior officials were allegedly ignored, and instead of registering an FIR based on Colonel Bath's statement, a separate FIR for a fray against unknown persons was filed based on a third-party complaint. A proper FIR was registered only after 8 days, following appeals to senior police officers and the Governor of Punjab. The court has directed the state to clarify several points, including the identities of officers informed about the incident, who refused to register the FIR, and the reasons for the delay, despite the availability of medical reports for Colonel Bath and his son. Whether medico-legal reports for the police officials allegedly injured Constable Randhir Singh and Inspector Ronnie Singh were provided to the concerned police officer for lodging an FIR. Whether medical alcohol tests were conducted on the involved police officers, and if so, to present the results. Colonel Bath has requested the transfer of the investigation to a central agency, citing concerns over conflict of interest, delays, and impartiality in the Punjab Police's handling of the case. Given the seriousness of the allegations, the court has granted the state 2 days to explain why the petition for transferring the probe to the CBI should not be dismissed. The matter is scheduled for further considerations on the 28th of March. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.